Is student visas under the microscope today? Brian, what do you think?
Yes.
It is under the microscope. We're going to talk about student visa. There's a lot to talk about. We got 10 minutes to do it or less. We're going to start with the news first. But the topic today, before we go into the news, so everybody knows, International Student Survival Guide, F-1 to H-1B. We're going to talk about the nuances of how you can put yourself in a position for success, or how can you discover that you may have an issue that you need to work on. But current event, I think a worldwide halt on issuance of student visas right now, pending revising how they vet applicants, social media.
Yeah, that is such a big immigration news story, not directly relevant to people in the United States, but it's just something we just can't resist talking about here. You know, big picture, I love student visas because they are the way that an average person might be able to come to the United States. If you don't have ties to this country through family or an already offer of employment, you know, it's a way that you might come to the United States and stay here and find a life here, you know?
But as long as you come in for the purpose of advancing an education without an immigrant intent or a long-term plan, with the intent to return home when you come in. So
of course,
it just opens opportunities, but if your intent is not to study or not to return home, then F-1 visa is not for you.
I will say a foul upon myself. You know, it's
just clarifying this point.
You're entirely right. Yeah.
But the other thing is also the State Department's announcement that they are now will begin revoking visa for Chinese national.
Yeah.
We were looking at some numbers here. The number of Chinese students in the U.S. today is staggering. 277,000 approximately student visa from China, only outdone by
India with more than 300,000, 330,000. So yeah, that thing about China is they said they're going to go after individuals with links to the Chinese Communist Party or working in sensitive areas. And, you know,
well,
I mean,
I understand the first one.
Yeah.
I understand the first one. But the second part is what I think it gets people a little bit perturbed. Now, I fully understand the national security concerns. I've always felt on a personal level, I have no other, you know, that there is a kind of a backdoor to our technology being, you know, leaking out to other countries that are not exactly friendly to the U.S.
Yeah.
So it is based on the topic you're studying. It could be, if you're doing a cutting edge work, your visa could be canceled.
Yeah, and I'm thinking about this, you know, I always think about how do they do that? How are they going to figure out where people are working? And I'm thinking they're going to probably go back and look at their I-20s. You know, every I-20 every I-20 basically says, hey, here's what you're going to be studying in the United States. And that's the sort of thing where I'd say that's probably the sort of analysis they're going to do, because it's, I mean, they don't have the means to personally vet, you know, 277,000, you know, Chinese students in the United States. I think their analysis sort of has to start with looking at those people and seeing what they're studying, and then making some guesses from there. But how?
You're underestimating the government's ability to vet 277,000 through electronic means.
Elaborate, please.
AI.
Well, that was what's on the tip of my tongue as well, and they're going to basically use AI and. I mean, they're going to go through SEVIS records as well, I guess. I mean, part of the SEVIS program is you're supposed to report who you're working for, you know? And they can really just set some sort of AI model right upon that.
I can't speak for the government, of course, and I'm not saying that this is what the government said.
Yeah.
But what I'm thinking is it probably the thinking, the analysis from the government is we're going to run AI. We can't vet 277,000 on our own. We're going to run AI to do it. And you know what? If we make a mistake on a 15 to 20% basis, so what? So be it, because we're trying to get rid of the bad guys.
National security, essentially.
Yeah. All right, so let's shift our attention on International Student Survival Guide, F-1 to H-1B. It's a lot there that we can talk about, and we have very little time, 5 or 6 minutes. So let's give people some tips very quickly on this very important issue, because we see it year in and year out. The number one issue that gets H-1B change of status denied is missteps.
Yeah. Well, Yeah, so maybe we'll talk a little bit about maintenance of status, and we'll talk about one of the big important rule changes. I'm going to just want to slide in before that the change to the cap gap. It used to be the H-1B cap gap, which I will explain the significance of, went to September 30th of the current fiscal year. Now it goes through the next fiscal year, April 1st, and I'll tell you what the cap gap is. So basically, if you are able to file an H-1B cap case before your F-1, your F-1 OPT, STEM OPT work authorization expires, they give you an automatic extension of your F-1 work authorization until the end of this quote-unquote cap gap. And now you get until April 1st of the next fiscal year, meaning there's kind of less of a need to file H-1B cap cases with premium processing, which is kind of good for the person who's going to be paying for it, be it you or your employer. They have less of a need for it, is the bottom line.
Yes.
Yeah.
Okay, excellent. So this is a cap gap update from the Biden administration. Last change that they've made before they've moved on. This is not a Trump change. This is a Biden change. Yeah. And that's what we have.
In January, right before they left office. Yeah.
Yes. Now, pitfalls, issues, STEM OPT, cap gap. What can you tell us?
So there's that question of if I'm going to be eligible for the cap gap, should I file for my STEM OPT extension, for example? And my answer to that question is yes. Your H-1B approval is never guaranteed until it's in your hands. Meaning, always file for that STEM OPT extension if you're eligible for it. Obviously, that requires you to be in a STEM field, but yeah.
So, I don't want to burn too much time on this very important distinction. If you do not have a job, cap gap does not force you to work, does it?
Whereas
STEM, if you did not work for more than 30 days, on STEM extension, you have violated the...
Oh, you're talking about, so that's just the cap gap, not the work authorization, without the work authorization extension. So I guess I'll sort of explain the concept. It's possible to take advantage of the cap gap that allows you to stay in the United States, but if things don't work out certain ways, the dates don't work out right, you don't have work authorization, meaning I see the point that you have, but you have to have a job offer on the end of that in the form of an H-1B in order to be eligible for the cap gap.
It sounds
like that's worked to your advantage once or twice, Sam.
You have to kind of figure out what is in your best interest. 99% of the time, extending the STEM OPT is, but not 100% of the time. How can we say that?
Yeah, I mean, the bottom line, I know 100%. It's if you find yourself in this, I don't have work for you for the summer, but I'll have work for you in the fall. You might want to be in a situation where you are not required or able to work, but can stay in the United States for sure.
Yes. So that's a good point to make, but please go ahead.
So one thing I just flipped past, but the thing that totally flummoxes people, or gets people in the end, is unemployment during your OPT or STEM OPT.
What are the rules?
So let's see here. While you're on OPT, you get 90 days of unemployment in the United States, and for the STEM OPT, you get an additional 60 days of unemployment. Meaning, when you get your STEM OPT EAD, for example, on its face, it's going to say, good for 2 years, right? But the problem you have is if you go, 150 days of unemployment during that time, suddenly your status is broken. Now, USCIS doesn't have or ICE in this case, because it's a SEVIS program, doesn't have, eyes on you. They don't necessarily monitor you should be reporting this through SEVIS. But the bottom line is you can break your ability to change from F-1 to H-1B if you run afoul of those rules.
And just so everybody understands, 150 is not exactly, you could find yourself in a bad situation with less than 150. So let's assume on year number 1, you did not work 30 days, and now you did a STEM extension. Now, during the STEM extension period, which is the 2 year, you cannot exceed 60 days. So you could be...
No, as I recall, you get an additional, 60 days, yeah.
And you can move on the 90 days into...
That's the
$50,000 question.
Yeah, let's have somebody ask that question specifically, but yes. Yeah.
So you have to be careful. If you find yourself in an unemployment situation during your STEM, talk to a lawyer because the calculations can be tricky. But bottom line is you have 60 days of unemployment during the STEM.
More for that,
additional 60 days. Okay, excellent. So unemployment, they look at that, and the training requirement, which it tricks everybody. People say,
For the STEM program or
well, I am in unpaid training right now,
Ooh, yeah.
but I am employed. And a lot of these trainings, USCIS cracked down on that in the last 5 years or so. And the training program must be a kind of an educational training.
Yeah.
Interning, I guess is the word.
Yeah, so during your first year of OPT, you're allowed to have unpaid employment. And that's where you hit that issue, where it has to be, Department of Labor has a sort of a policy and rules for it. It must be essentially, look, more like educational than work, otherwise they're not going to consider that to be lawful.
There's textbooks or material you have to study, you have to learn, you have to show that there was an educational component.
Yeah, they're not just putting you to work and not paying you for it, but also as part of the STEM OPT program, there's the form, I can never remember, I think it's the form I-983, whereas that program has to be sort of, even so during STEM OPT, you're not allowed to be unpaid, but there's sort of a training component of that program on a form called I-983, and it's people who have been through the STEM OPT in the last maybe 10 years ago are surely aware of that.
Okay, so one more minute. Curricular practical training, CPT, day one CPT, problematic, sometime why?
So here's what I will say about it. They love to issue RFEs on this topic. They are very interested in people who have done day one CPT through the maybe 20 or so universities that handle it. Now, I can say, Sam, that I cannot recall a scenario where I've ever lost a case on, I don't have a perfect memory, but basically here's my analysis on when I tell somebody if they're thinking about doing it, I say, they sure do love to ask questions about it, but those schools are very experienced in giving you what you need to respond to those RFEs. And anytime I submit that documentation, I'm at this point reasonably confident that they're going to do it.
The key is the physical presence to a certain key classes.
Yeah.
And that's really, and if you don't
making
do
sure
that,
you're checking all the boxes.
Yes.
But Sam, if I had to think about this change of administration and are they going to be interested in the program? Are they going to close that loophole? That would be a question that I'd say, that's an interesting one.
I'll throw another 30 seconds before we switch on job change during the H-1B process if you're an F-1 student. That's an issue also that we struggle with, where somebody says, you're selected in the lottery, but I filed this H-1B and then things change. A change happened. The job is no longer available, or you want to go somewhere else. I mean, these scenarios can really disrupt your H-1B ability, and there are scenarios where you can lose that lottery selection.
Yeah, you mentioned change. I don't know why I just jogged my memory. Here's a very common pitfall in terms of H-1B cap cases and going from F to H. Travel outside the country. If you leave the country while an H-1B a change of status to any status is pending, they will consider that change of status request to be abandoned. Meaning you have to talk to your counsel or your employer about travel during the pendency of an H-1B cap case, and usually the answer is please don't.
There is an article in the Wall Street Journal about fear of student leaving in the summer, and I was quoted in it saying that if a student comes to me and tells me I'm planning on leaving the United States during vacation right now, I was quoted to say that if you ask me that question, I would tell you you're crazy. And they quoted me in Wall Street Journal, I think yesterday.
Well, this is where.
But I would say to tell you you're crazy if you leave right now. But back on the job loss, because we're running out of time. There's intricate rules, and I'm not going to go through them, but if you're finding a job change, you need to consult with an outside lawyer, because there is a lot to it, and there's a lot of also a gray area, and some employers' attorneys are not aggressive enough to take advantage of these gray areas, and so there's a lot going on there that can really make a big difference in your case.
And there's so much at stake now, especially with the amount of scrutiny they're putting on visa stamping. It's not the sort of thing where, if they change it to H-1B is not successful, I just get another F-1 stamp because, well, again, all countries freeze on F-1 visa applications. Presumably that's going to resume, but I would bet whatever comes out of that is scrutiny on F-1 visa applications is going to be more and greater.
It is under attack. I think probably the administration feel that this F-1 visa has been going under the radar for so long, and we're going to clean it up. And that is going to put so much pressure on students.
I mean, I've been critical of the policy of some of the policies of this administration, but I mean, I can't argue with the facts. There's a lot of times where you hear, they have a problem with somebody, and it's, overstayed student visa is a very common scenario.
Wonderful. So Thank you guys for listening on that part. We're going to go into questions if you have them, and then we have immigrationquestions.us, which is our immigrationquestions.us, right? Which is our website. And then sometimes there's questions there that are posted, and then if they're posted, we will answer them. Regardless, let's go take questions today from people first because they have been patient with us.
Yes.
And so let's take that.
So let's check out this one from Wesley, who is, and I'll put this in front of us so we can actually see. And I'll put this over here because I got to log into immigrationquestions.us if I'm being an honest guy. Question from Wesley, who says, "Are you seeing an uptick in green card, EAD, RFEs, and interview requests? I got my immigration documents via FOIA, and the I-45 has a stamp that says interview waived. Should I expect one? Priority date December 2013, EB3." Well, your thoughts?
My thoughts that this interview waived means nothing.
I would agree.
It's good news, by the way. So it doesn't mean 100% nothing.
Yeah.
But it means nothing vis-a-vis whether or not you're going to be interviewed. Because at the time it was stamped, there was a policy, and then during
waive everybody, waive everybody. Most employment,
waive cases that look good on their face. I mean, they're not going to waive a case that does not look good on their face. I've been to plenty of
employment interviews, sure. Waive a lot of them.
Yeah, this case looks good. I don't see a reason to interview, and therefore I'm not interviewing.
Yeah.
Stamp. Then there is a change in policy that says don't waive anybody. So they're going to take these cases out and interview people. But that tells me that whoever looked at your case thought this case is a good case.
Yeah, I'm on the same page as you. It's don't count your chickens before they hatch. It looks like you have a chicken, but they can put that chicken back in its egg to butcher that metaphor a bit. So there's that. So let's go and check this question here from Y. Hori. And Sam, would you be able to read this one while I go ahead and grab those immigrationquestion.us questions to the best of my ability?
Yes, certainly.
If I can.
Y. Hori, he got called on an interview. All right. Can he adjust can he AOS? He said he knows other people who adjusted using the same route during Biden administration and got their green card without interview.
I apologize.
So there's a history.
Oh, geez, there's a whole lot of questions here that I skipped, so maybe we'll come back to that one a little bit later. How about
Let's give priority today to our audience, and we'll take care of the.
Fair enough.
So I'm sorry for the previous gentleman. We were going to get to you first. I think we're jumping around.
I actually scrolled down and clicked too early.
Blame it on Brian, not on me. But I will
blame
take
on Brian. Okay.
But I'll take care from Raja Prohit. Hello, sir. Just like 60 days is the grace period for job loss of H-1B holder, is there a grace period for job loss for green card EAD holders? That's a great question.
Yeah.
I love that question.
I have a great story. I'm gonna tell a story about a guy I know. Mm-hmm. I know a guy, nice dude, out of work for about a year with a pending green card, as best as I can tell, right? And no action on his I-45 case. And he talked to me, said, "Brian, do I have a problem?" I said, "Well, not necessarily right now, but you should really find yourself a job because his priority date's current. He has a job. If anybody ever asks, basically, he'll be able to get a supplement J out there. And that's it for me until I hear otherwise. There's that. But this guy was out there for about a year, no job, no problem. Anecdotally, of course.
Did he get his green card yet?
He's still waiting on that.
So
on that final decision.
No problem yet.
Well,
1 year is a long time, Brian. But for this gentleman, there is not a grace period for green card EAD holders. So let's answer that question. Yeah. Number two, a long period of unemployment is problematic. I would be concerned about your friend.
Oh, I told him I was concerned about him.
Yeah, I would be concerned about him. That a year of unemployment, if he's current, because now he's going to show up with a job that's only started 6 weeks ago, and then hasn't been working for a whole year. Now, if the priority date, let's say, is 2020, and there's a year of unemployment, but followed by 6 years of solid employment when the interview occurred, I would be less concerned because that 1 year now is too far in history. So this gentleman I would be worried about, but no grace period for green card EAD holders.
Yeah, if you have a long pending I-45 more than 180 days, they contemplate changes in employers. That's built into the rules, but they never say exactly how long.
I don't know much about your case, but I will add one more fact that would make me feel good.
Yeah.
For example, an offer of employment from, let's say, a Fortune 50 company.
Yeah.
Right? He ported his green card with Supplement J to an Amazon or a Microsoft or an Oracle or something like that.
Oh, sure.
Then that is
Would make somebody feel warm and happy. Forget about
better.
this. You're a fancy guy.
But under 1 year of unemployment, and then you get into a job that has 5 employees in that company that doesn't have a history, I would be worried about that.
His I-485 is already out there, already filed. You don't have to. They're not going to ask again. They're going to ask that interview theoretically. Where are you working now? He's going to have Supplement J, and I'm crossing my fingers. If they choose to interview.
Some interviewers don't care. Other interviewers care a lot.
True, yeah.
Yes.
Yeah.
All right.
So here's a question here. I tried to submit this question online, but it's not allowed me to submit the question. So that's maybe an immigrationquestions.us sort of issue there.
Okay, sounds good. I will definitely study that and get back to you, and we'll get that fixed today.
Yeah. Here we are from Granin. Can an independent physician establish a medical practice on E2 visa? Any premium processing available? Who?
Okay. 100%.
Yeah.
A medical practice can establish a practice on E2 visa if you are from an E2 visa country, for example, if you're Canadian.
Yeah.
Provided that you have the licensing required to conduct the practice in the U.S.
That's the big thing that hits me. It's like a chicken and egg thing. If you're not in the United States.
But you don't have to. For example, let's assume you have a foreign license of a certain field.
Yeah.
You can probably find an allied profession or a support profession, that does not require licensing.
Yeah.
In the medical field, to get you started here, whether maybe home health care or some kind of a profession that you can do
in the vague industry, such that once you're here in the door, you can basically convert whatever licensure is to the proper one in the United States and
get your license, get things, and then
Yeah.
update your E2 visa. That's an idea, for example.
So premium processing available. So if you're inside the United States and you, to the best of my knowledge, it's still available for E2 applications. But at the consulate, there's no premium processing at the consulate. Most E2 cases usually start at the consulate, where you submit an application package to the consulate, and they will take however much time they think they need in order to review that.
Typically, between 2 to 4 months is the window that I see most cases.
Some major ones have a little bit longer time.
I see a high level of responsiveness from consulates on E2 visas.
Highly professional and responsive.
yeah.
Even if I remember last one I was working on, I was out of London, and it's basically the client was getting a bit antsy, taking a little bit long, and they would respond to your emails.
Yes.
Consummate professionals for sure.
Yes, absolutely. And they have an E2 visa. Every consulate has an E2 visa unit that's trained in the field. Yeah.
So I think we. I thought we answered this question. No, from Wesley we did. So I'm going to skip that one. I think it's a repeat. Going to hit Waihori here.
All right.
This is the one we
asking for a friend.
Yeah.
Came with an F-1 visa and he overstayed. He applied for EB2 National Interest Waiver. I-140 is approved. Then traveled with EAD advance parole. As soon as he came back, withdrew the I-45. He reapplied another I-45 now.
And here it is, the question
He got called for an interview. Can he adjust status? He said he knows other people who adjusted using the same route during Biden administration, got their green card without an interview. So here's a scenario they're talking about. Somebody came in on an F-1 visa, overstayed, okay? Then filed for I-485, got an advance parole, re-entered on parole, and then he withdrew and filed another one because now he's parolee. And then
you file it.
And then he filed a second adjustment because as a parolee you can adjust.
Yeah.
And then it went through.
So they shouldn't approve these cases, in my estimation, Sam, because you said he re-enters as a parolee and files a new adjustment. You must be in lawful immigration status to file, unless you're in an I-8 245 case scenario. Lots of
parolee can adjust.
Parolees can adjust. But for an employment-based case, you must be in lawful status, is my recollection of the rules. They have that rule for, a family-based, parolee can adjust. I think employee-based one should be in lawful status.
Okay.
Is my recollection on the subject.
Okay.
Which means,
The devil in the details with these cases, and I would probably want to know more. Where I have a problem with this is the finding of, if you're relying on that parole to adjust, yeah, it could probably go through, assuming everything is okay. I'm not making an opinion on it. Let's bypass that technicality for a second.
Sure.
But where I find the problem is that the adjustment was filed in bad faith. To begin with. So an officer who's not experienced probably will let it go. An officer who's experienced is going to say, pause. I don't like this.
Yeah.
This is working around.
Yeah,
the
there's a
system.
lot of officers who don't have much experience with employment-based immigration, and that, that is a scenario where...
And there's no need to do that. You can do consular processing.
Yeah.
And get approved and come back without having to play games with the system if you haven't approved I-140 and you're current.
Yeah.
5-6 months and you're back here and it's clean and there are no issues and there are no concerns.
Yeah, well, I would say if you overstayed an F-1 visa, there might put a little bit scrutiny on you at that consulate there, but that shouldn't make you inadmissible overstaying on an F.
Yeah.
Yeah.
So I got a question here that came in that says, I'm a F-1 student right now from China, and I work in a critical area that's sophisticated, advanced. If I get my visa revoked by the USCIS, do I have a recourse?
The visa stamp, you said visa revoked by USCIS.
The status revoked by USCIS.
Status revoked by USCIS, that sounds like that's been a litigation thing. That's where the prior sort of...
So what's the argument for and what's the argument against? Because the argument for it is this is a national security concern. Now, when they revoke your CVIS, they put you out of status right away.
Yeah.
And you can go and file a lawsuit.
Yep.
And you can probably, if you have a sympathetic judge, can reinstate you. But if the government comes in and say, we have a national security concern, continuing this person's visa, what's the chance of this person succeeding?
Very, very low. I mean, when I was talking to somebody, go ahead.
I would think the judge would want to hear more about that.
Yeah,
Some kind of an explanation, right?
Yeah, but I mean, I was just talking to somebody about a mandamus action this morning, and I said, I was telling them the ultimate checkmate the government can do is like, no, it's a national security, and we can't share it with you.
But the judge can force sharing it in chambers.
Yeah,
So the judge can say, you're going to come into my office. I'm going to allow an exception because of national security to come to my office and give me some documentation and make your case in chambers on national security.
Yeah. I mean that can happen. It's just
But the government is going to go through 277,000 cases.
Yeah. I mean that's I mean I'll agree on the fundamental question of you can challenge this, and the bottom line is I'm sorry guys, you didn't make a decision based upon something out there. You didn't make a decision based upon me, and I'm not at the consulate. I'm in the United States right now. I have certain rights. I'm going to try to assert them in court. Yeah.
But the opportunities are limited.
Yeah.
All right. So
a couple minutes here.
Yeah, sure.
So Ranyan, who's having that problem with an I-45 MTR. While having pending MTR, if we go out of the country and get H-4 stamped, can we continue working on previous MTR-related EAD? So I think this is probably a sort of intense question. Probably. Well, go ahead. Give your thoughts.
Well, I think these questions need to be in a consultation setting because Ranyan, I know you're concerned. I'm sorry about your MTR not coming through, but the questions really need more of a consultation where the whole picture is put together, and you can put together all your questions. I mean, whether in our office or any other law firm that you trust, to come in and just say, okay, here's my 8 questions. Here are all my documents. I want to play out 5 different scenarios, and some very smart lawyer can go and look at these documents, create a timeline, read what's in the RFE, read what's in the response, what is exactly the issue, what's the likelihood of success, and what is the very dangerous route you should not be taking, and what's really the favorable route you should be taking.
All I would say to add to that is anything I gathered from Ranyan, because Ranyan's been telling us about this for a while, is that if it's a genuine error, USCIS is generally open to taking MTRs when there's legitimate government errors. I mean, we do a lot of family-based MTRs. They'll take it when it's the petitioner or applicant's error, usually a couple of months. So I know it's really difficult to wait it out.
Yeah.
But you know, there you go.
Amy got a question. We're on the last minute, so let's see if we
got
can.
Wesley one in there, dude. We'll take Amy here and try to.
Hi Sam. At airport point of entry, they are not putting entry stamps in passport anymore. My mistake or system error. If CBP doesn't have the record of the data entered into USA, then how do we prove date entered? Is there any alternative way to show the dates entered? Thank you. Well, obviously, there's the case we just finished doing where the CBP made an error and it was discovered 8 months later. Until today, they're correcting it. So CBP has corrected its error, so they understand. So for you, Amy, number one, when you enter the United States, you need to go to a CBP website, I-94.gov or something similar to that, and look at your entry record online. You can enter your passport information, and you should be able to enter your record, unless you're coming from Canada.
Yeah, good perfect public service announcement though. Pull your I-94 immediately, because that will save you. If you travel a lot, it's going to save your butt eventually.
Yeah. Now, if you did not find a record of entry, your I-94 record online, which you need to download and print and save in a safe place, then you need to contact CBP and request that to be corrected and to create that record for you, and they will do that. And you do have your flight details, and it's fresh.
Yeah.
So you do it. You come into you land today in the United States. Go ahead and rest, take a shower, have dinner, relax, sleep. Wake up next day. First thing, log in. Give them 24 hours. Give them 48 hours. Log in and look at your record. Your passport number, your name, your date of birth are required. You're going to see it. If you don't see it, contact a lawyer or go online and contact CBP at the airport and say, I don't have it, I need it fixed, here's my flight record.
Yeah, I mean, the fundamental question of documenting it, you have a flight record. Yeah. That's pretty darn solid and good. Yeah. So I want to answer Wesley's question here real quick, even though we're slightly over, because it's a good question and pretty straightforward.
Let's do it.
What documents do you need to create the I-45J bona fide offer documents as a previous perm and current job description? So I think Wesley's asking the question, how do you show same or similar occupation? And as the one that additionally underlined the I-45, and yeah, you would need the perm, the previous perm that underlined your original I-140, I-45, and whatever that current job is. And you know, at a law firm like us, we have a sort of little method of sort of comparing them, doing an analysis, and saying, yep, these things look the same because they sort of have the same threads amongst them. So if you're trying to do a good comparison, that's really what you need.
Or it doesn't have to be same; it can be similar.
Yeah. Yeah. And I'm going to answer this last question here. Well, if somebody's asked a question I'm not going to answer directly, but if you're interested in talking to us, our lovely website there is right at the bottom. And I would say head on over to immigrationvisaattorney.com and you can find all sorts of information.
You can just go into connect with us and we will be happy to help.
I believe it's also in our YouTube video description usually. Yeah. Thanks, Alyssa.
All right. With that, we conclude today's presentation. We'll see you guys on Wednesday at 6 o'clock Eastern Time for another topic of your interest, of your